Hi everyone, good evening. This session is dedicated for AILET Legal Reasoning, and what we are going to do is we will solve the most brutal questions, the most trickiest questions in legal section that AILET has asked previously, AILET or Clat, wherever that kind of question. So See, what is important is for AILET, I would say that you don't have to study anything else separately for legal because whatever was done for CLAT, that naturally also covered AILET, undoubtedly. But yeah, the AILET goes has a different approach with respect to some questions in legal. I would not say in all questions. Majority of questions can be solved the same way we did for CLAT, but yes, in some questions, AILET has followed a different approach sometimes, slightly unpredictable answers. So I have picked up those questions for you and combined them, compiled them so that we can all solve that and get a better clarity on from AILET perspective. Okay, so these are the questions that I really say that they can make or break somebody for uh, AILET, right? Because these are the questions that really create difference. Okay, so not everybody is able to do them, and that's why they create difference. Otherwise, if the question is very predictable, foreseeable, तो फिर सब लोग कर लेते हैं तो उसमें इतना ज्यादा डिफरेंस क्रिएट होता नहीं है. Anyway, let's look at let's start the session without delay. And this is the first question. You have to read the principles and then you can answer on the live chat. You can answer first, read the principles and I'll show you the facts. Okay, let's go to the questions now, to the facts now. Post your answers in the live chat. Yes, I'm waiting for your answers in the live chat. Let me show you the principles once again. Okay, here are the principles. Now, look at them carefully once again, and then we'll go to the facts again. Yeah. Now give me the final answer. So Ifa says B and TG says D. Okay. Okay. So almost everybody is going for B as the right answer, but surprisingly, like I told you, AILET, these are tricky questions. So the right answer for this question was option A. Right. Option A was the right answer. Now uh, option A is problematic because it has a suggestion also at the end of the statement, and also because it says that there is no nuisance. Right. But here is the logic behind it, that if you look at the question, it says private nuisance, the principle says private nuisance is a continuous, unlawful, indirect interference with the use or enjoyment of land or of some right over it, etc. And then the third principle says generally nuisances cannot be justified on the ground of necessity, pecuniary interest, convenience, or economic advantage to a defendant, whatever it is. See, the point is that use or enjoyment relates to basic use or enjoyment. Okay. Now, this is what is not mentioned in the principle. That use refers to basic use or necessary usages of the land. It doesn't include luxury usages or usages which are beyond what is necessary. So watching a television is definitely a use of your property, but cannot be considered to be a basic use, cannot be considered to be a necessary use for enjoyment of property or land or building for that matter. So that the fact that somebody is unable to watch television because of an external interference is not nuisance. In reality, also it is true. Understand, a person is unable to sleep because of loud music outside is nuisance, because sleeping is considered to be an essential part, to be a necessary part, to be a basic part of a property. But watching a television, unable to watch a television, etc., is not. Okay. So now what happened in this question? It's an elite question, and elite question is always understand that elite questions, the right answers are based on the actual position of law rather than the hard letter of law. Okay, unlike Clat. For Clat, we saw that we stick to the principle of the passage absolutely 100% in all cases, no diversion at all. But in AILET, they go by the actual position of law. Okay, so in nuisance, remember this, that use or enjoyment refers to basic use or enjoyment, does not include luxuries or unnecessary usages. I hope I'm clear on this concept. Give me a thumbs up on the chat box and I will see. Give me a thumbs up in the chat box if you are able to understand this question. Let me know to proceed or not. All right. So this question is done. Fine. Uh, I'm leaving this question because I believe you must have done it. Let's look at this question. Yeah. It's a long question. Yeah, okay. So the answer to this question is C. All of you are correct. Uh, if you have studied vicarious liability, you would know that if there is a connection between the act which has been done and the act for which he was authorized, right? So if there is a decent connection, or we can say that if the authorized act gave him the opportunity to commit the tort, then the master is liable vicariously. So this is called the close connection test, the close proximity test. So yeah, obviously C is the right answer because the warden was he actually got the opportunity to commit this during his employment of that certain nature. Aditya, level no, sorry. AILET is on the tougher side. I would say when you talk about legal, generally AILET is on the trickier side, on the more tougher side. Okay. All right. Give me a thumbs up if you're ready to move ahead, everybody. No doubts in this question. Here is the next question. Yes, everyone, give me your answers in the chat box. I've received a few answers in support of B. Okay. Okay. Yeah. So all of you are absolutely correct. And I'm very happy to see that you have cracked this question successfully, because when this question appeared in AILET, it was difficult. It was found to be very difficult, and most students did it wrong or left it. But I'm happy to see that you have marked the correct answer, which is B for Bangalore. What is happening here is that if you look at the facts, especially the fifth line, in accordance with the approved police procedure for administering cautions for suspicious behavior. So the only authority that she had was to deliver a caution, was to administer a caution. Caution means a notice or a warning, you can say, right? That's the only authority that she had as per the facts. Now, the and anything that happened further, she went beyond the authority and physically contacted her, held her arms. That is not a lawful exercise of power according to principle 2, and therefore it becomes a case of battery. It's also a real case. Because the power was restricted in this case, there was no power to arrest as such. Okay. So yeah, let's move ahead. Give me a thumbs up if it's clear to you, all of you. And also, if you have any doubts, please post in the live chat. We can discuss that also. So I see that you are not doing too bad for elite. At least legal, you are doing good. Next question. Okay, so yeah, this is also a trick question, a good question, and again, uh, probably could not have been derived strictly from the principles, and you had to, you really apply your common sense, basic common sense, or the established principles of negligence that you were taught in the classes, your overall understanding of taught, all of that would be required to solve this question. And I'm happy again that a lot of you have gone for option A. In this case, option A is the right answer, because if you look at the third principle, it says the claimant must prove that harm would not have occurred but for the negligence of the defendant. That is, the claimant must prove on the balance of probabilities that the defendant's breach of duty caused the harm. So, if you remember, we were when we when we had done negligence, then we also studied a rule of causation, that was that if the negligent act is the sole reason behind the result, then the defendant is liable. Right. Now, in the facts, it is mentioned that there are 25% chances. So here is a medical rule that you should also note down. The medical rule says that if there are less than 50% chances uh, in any case where there was a misdiagnosis, right? Less than 50% chances in case there was any misdiagnosis by a doctor, then whatever be the result, the doctor is not liable under tort. Do understand that we are only concerned with the doctor's liability under torts. We are not concerned with the doctor's liability under the medical rules or practice rules or departmental rules. We are not concerned with that. Maybe his license will be questioned or considered for suspension, whatever. We are not concerned with that. We are only concerned with the liability under tort, that whether the doctor will pay compensation, whether the hospital will pay compensation for the injury or not. The answer is no, because 25% chances is too less to impose any blame on the hospital or the doctor, right? This is also a real case. And see, the AILET went beyond the strict application of principles and applied the correct position of law. So some of you are able to do that, very good. For those who did the wrong answer, कोई बात नहीं, अभी समझ लो इस रूल को. Less than 50% rule is for medical negligence. Okay, I hope I'm clear. Give me a thumbs up to proceed or not. Yes, next question. Be careful. Sorry. Yeah, so C is the right answer in this question. All of you are correct. See, what is happening is there is an indication that uh, first of all there is an employer and employee relationship where it is presumed that the employer is dominating and would must have used the dominating position against the employee for his advantage. Right. And secondly, the fact that Pragya, who is the employee, had nothing to benefit from the transaction also is an evidence, sort of an evidence or an indication we can say that she was not willing to do it, or maybe it was not her for her favor. Okay. Now, there is no need for forcing anybody in case of undue influence. Force is generally used in case of coercion. And the principle here is not of coercion, the principle is of undue influence, right? So, C is the right answer. Undoubtedly, all of you are absolutely correct. If there is any doubt, let me know for anyone. Anybody who did not understand the question or uh, any other problem, let me know. Otherwise, give me a thumbs up to proceed. Okay, next question. The right answer is option A. Again, instead of just relying on the principle, the correct position of law would be the right answer, right? Like I said, and the correct position of law is that in CRPC or BNSS, which is the correct law, current law, it says that if I am asked to be a surety, to bring a surety, then the surety refers to a guarantor, right? So if somebody has to stand as a guarantor for me, then he has to pay the money out of his pocket. That's the whole purpose. The whole purpose is that, let us say, if the court says to me that bring a guarantor, and I bring my friend as a guarantor, then the friend who is acting as a guarantor, he has to feel the burden of guarantee. He has to feel the burden of guarantee, which is not happening in this case. That's the whole purpose of CRPC. But यहाँ पे तो उसने उल्टा कर दिया. He himself is depositing the money, so the guarantor doesn't have any pressure of guarantee, does not have any obligation of guarantee, right? So A is the correct answer. uh, Short question but based on legal concept. Okay. uh, So now I guess you are able to identify the pattern on which AILET is based. It is more common sense oriented, more legal position oriented than just relying on the principles 100%. Am I clear on this, everybody? Let me know. Proceed or not. All right. Next question. Everybody give me your answers quickly. Yeah, so C is the right answer. Very good for the ones who have done this correct. C is the right answer. See what is happening. Understand that there is a rule of contracts that let us say I have promised to sell you something at a certain price and I broke that promise. Okay, two things have happened. First of all, I have promised to sell you something at a certain price, and then there is a breach of promise from my side. Now you have to buy the same thing of similar quality, same quantity, right, from the market. You are forced to. Now in the market there are two things available at, for two different prices. The exact similar thing that I had promised is available for a certain rate, and a slightly better thing, I would say, is available for a different rate. So the law says that if in the market it is available, if is the word that needs emphasis. If it is so available that you could have bought the similar quality, same quantity from the market, then that price is the base price on the basis of which difference will be created. Okay. It's like I book a taxi for to airport and he said 500 rupees. Then he cancelled. Then I looked for another taxi. Now I had two options. I could have booked a. So I had booked a sedan initially, let's say, and I was getting another sedan at 700, and I was getting an SUV for 1000. So I booked SUV for 1000. Now when I see compensation, I will not get 1000 rupees because the court will say that the car, the quality or the level of car that you had booked was available for 700. So 700 minus 500, you had to pay 200 rupees extra. How much extra did you have to pay? That is 200 rupees extra you had to pay, right? That's how it will be calculated as the compensation. Similarly, in this case, 100 rupees was the agreed price, and then he bought it for 110, but he could have bought at 105 also. So we will not consider 110 for calculation. We will instead take 105 for the calculation. Okay. I hope it is clear to all of you. So the right answers will be C based on the calculations that you do. So very good, the ones who have done it right. It was a very difficult question, but I'm happy to see that you are able to do it. Let me know to proceed or not. Next question. So in this case, there is a confusion. There might be confusion, but your answer is correct. A is the right answer. Mm, so it says that intending to restore it to Z at a future time. So that is not relevant. What is relevant is what is the intent at the moment. What is the intent later on is not relevant. Okay, he has used in criminal misappropriation. We had studied that if the accused knew that or could have known that who is the owner of a certain property and could have located the owner, could have found him, but did not make reasonable efforts to find him and used the property for his benefit of whatever nature, then he is liable for criminal misappropriation, even if he might have a it might have an intent to restore it, but restoration is not relevant. In no crime, restoration is considered to be an excuse. Okay, if you've committed the crime, you have committed it and you're liable for it. So clearly A is the right answer because his use was wrongful in the present case. Only two of you have answered this. Okay, I hope everybody else is also able to understand. Any kind of doubt, any kind of query, let me know, or we go ahead. Next question. So, this question is also based on correct position of law. Although in the principle it is mentioned that any institute or body can be a state if it is created under the constitution, etc., etc. So all of that we don't know about BCCI. Right. The only question is that K approaches the High Court by filing a writ petition against the BCCI, and the argument advanced was that BCCI is a state within the meaning of Article 12. Now, it needed your understanding, your prior, awareness when we had done Article 12, when we had studied Constitution. You would know that this the BCCI is actually not a state, because it is neither created by a state nor any part of it is controlled by state. It appears to be a state because the positions are filled by the government, but uh, it's not really a state in in literal sense, in legal sense. So D for Delhi would be the right answer. Good. See, let's say if AILET gives you 15 questions in total. So out of those 15 questions, only 3 to 4 questions are such questions which would go beyond the principle. And see, understand the philosophy of AILET. AILET always gives correct legal position based answers. What is correct legally will be the answer. And in 10 to 11 questions out of 15, they will follow this rule. They will give you the correct principle of law that will help you derive the correct position of law. In 3 to 4 questions, like I said, they don't give you any hint and you might be confused. But then, with common sense, with basic awareness, with your general knowledge, you can still do those questions right. Okay, so don't worry. The chances are good that you will do legal well only. Like in Clat also, I had said that legal will go well. Don't worry about legal. Similarly, in AILET also, it's more likely that you will do it well. You're well prepared for legal. Okay, let's go ahead now. Next question. Yes, any other answers apart from this? Okay. The principle is based on constitution and reasonable restriction in particular. Now we know about reasonable restriction that restriction is considered to be reasonable when there is a relation between restriction and the purpose, and that it has to be necessary, it has to be fair, it has to be proportionate in the sense it needs to be basically the best available course of action. Okay, what do you need to understand about a reasonable restriction is that it needs to be the best available course of action. Now, looking at the facts, think about it. Was it the best available course of action? What is happening? Let's identify the problem, and then we'll look for possible solutions. We will look for possible solutions, and we will see that whether there are any less harmful, less damaging, less harmful possibilities are there or not. ठीक है, अगर लेस हार्मफुल पॉसिबिलिटी नहीं थी तो फिर गवर्नमेंट ने जो किया वो बेस्ट है, बट अगर लेस हार्मफुल कुछ था तो दैट शुड हैव गवर्नमेंट डन, देन इट विल नॉट बी रीजनेबल रिस्ट्रिक्शन. सो देखो प्रॉब्लम क्या है कि शॉर्टेज ऑफ लेबर है फॉर एग्रीकल्चर पर्पस बिकॉज द लेबर इज एंगेज्ड इन मैन्युफैक्चर ऑफ बीडीज. ठीक है, टोबैको मैन्युफैक्चर में लेबर एंगेज हो रही है. तो गवर्नमेंट ने, बिकॉज एग्रीकल्चर इज ऑल्सो इम्पॉर्टेंट, राइट, सो अगर एग्रीकल्चर में शॉर्टेज होगा तो दिक्कत हो जाएगा इन इन टर्म्स ऑफ पब्लिक इंटरेस्ट. तो द गवर्नमेंट इनेक्ट्स लॉ कि भाई अब कोई एग्रीकल्चरल लेबर जो है वो बीडी मैन्युफैक्चर में या टोबैको मैन्युफैक्चर में नहीं जाएगा. ठीक है, तो इस चीज को इस तरीके से समझना है कि कंप्लीट बैन कर दिया है. मतलब एग्रीकल्चरल लेबर अगर है कोई तो वो जाएगा ही नहीं किसी और इंडस्ट्री में, स्पेसिफिकली बीडी इंडस्ट्री में नहीं जाएगा या टोबैको इंडस्ट्री में नहीं जाएगा. बट द क्वेश्चन दैट नीड्स टू बी थॉट अबाउट इज whether can you occupy a labor in agriculture for the whole year. Answer my question. Can an agricultural labor be occupied throughout the year in agriculture? उसका उतना यूज है पूरे साल या नहीं? Will the government be able to keep him employed? Because considering the fact that agriculture is based on seasons, right? So it's only seasonal. It's a seasonal job. Being an agricultural labor is a seasonal job. Okay. And that logic is found in option D, which says that it could have been achieved by restraining the employment of agricultural labor in other industries during the agricultural season only. So that would ensure that they are never unemployed. Otherwise, they will be employed for some time and then unemployed for the rest of the time, right? But by allowing them during the season, by restricting them during the season, will ensure that they are completely thoroughly employed. So, a very good question, in my personal opinion. Some of you have done it right. Very good. जिनका गलत हुआ था, I hope now it is clear. Give me a thumbs up if you have understood this question. Here is the next question. Next and the last question for today. Yes, answers quickly. I'm getting no response. What is your answer? Okay, so here the answer is option D, D for Delhi, which says that the statement is correct. Now, what is happening? What is judgment in personam and judgment in rem? Let us say if you and I have a personal dispute, a private dispute, and in that dispute, a judgment is delivered by the court wherein, either there is an obligation upon you or me to do something, right? So that's a judgment in personam because only you and I are bound by that judgment of the court. Nobody else is. Okay, the judgment affects or impacts only the both of us. But judgment in REM would be a case where there is a decision that is applicable on everybody, which is not a person specific, which is not even a group specific, where everybody, for everybody's interest, that judgment has been issued or made. So, a statement, the facts are correct in that light that if it is a uh, contractual obligation, then it is judgment in personam that affects the parties privately, only those parties, and otherwise it will be a judgment in rem. If the court has declared somebody to be insolvent, now understand how is it a judgment in rem? If the court has declared somebody to be insolvent, that means this man is not capable of financial transaction or is not capable of fulfilling financial promises. So, in a way, the court is issuing an instruction that nobody should deal with this man. Declaring somebody to be insolvent, what impact will it have that don't deal with this man? His financial abilities are under question, and therefore don't deal with him. So this instruction, this caution is for everybody. Is not only issued to me or you or any other party, right? So what do you have to say? What do you have to think in judgment in rem or personam? Not that about whom the judgment is. No, not that. But the impact of the judgment, the effect of the judgment. Okay, if the impact is large, public interest oriented, then it is judgment in rem. I hope I am clear on this. Let me know, give me a thumbs up, or ask any doubt that you may have. This was the last question of this session. We will come up with more such difficult questions in upcoming sessions. But do let me know if this particular instance is clear or not. I'm waiting for your responses.